Hi everyone, this is Dominic Holt, Public Policy and Communications Coordinator with Ian Henderson, Director of Legal and Systems Services at WCASA. And we are getting this webinar underway. Thank you much for your attendance. So today we're talking about the new victim accompaniment law in Wisconsin. So this is now called the 2015 Wisconsin Act 351, also referred to as Senate Bill 323 during this legislative session. Victim accompaniment, as many of you know, has been something that WCASA and friends have been working on for a few years now. And it really is a win-win-win for survivors and advocates, the healthcare system, the criminal justice system as well. And this achievement really exists because of the wonderful work of folks like you, activists, citizens, advocates, partner organizations, statewide partners, etc. People who've been educating lawmakers and thought leaders and the press about the importance of this bill and this new law. So a big thank you to everyone for your responses to our action alerts, for your independent actions you've taken, for your collaboration with us. Your voice does make a difference, and this law is certainly an excellent example of that. So a big thank you to everybody. So how did the law come about, or what was the genesis, so to speak, of this bill and law? Basically, we had heard for some time from survivors and sexual assault victim advocates that something like this bill was necessary, just given experiences they've had at law enforcement interviews and medical forensic exams. And so this led to, as many of you know, a long and complex process. Legislation always requires a long and complex process usually to become a law, and there were a lot of really conversations, comprehensive negotiations that took quite a while, but good things sometimes take a long while, and we did have to make some hard choices in consultation with our membership-based Public Policy Advisory Committee, and therefore had to have some compromises in the bill.
Hi everyone, this is Ian. Just to piggyback on what Dominic was saying, I think the other piece, in addition to feedback we heard from survivors and advocates, was we believe that this legislation is best practice. And we can point to protocols that indicated this was best practice. And while those have been helpful, I think they weren't necessarily enough to maybe see that practice adopted on a statewide basis. And we also know that survivors get better outcomes not only in the medical system but the criminal justice system, and likewise the criminal justice system, there are better outcomes for that system when advocates are involved from early on in the process and are helping survivors navigate those systems.
And before we move on, I just wanted to mention two little housekeeping points. One, please ask questions at any time that they arise. We do have, I think, an hour and a half for the webinar because we anticipate there may be questions, and answers may also be rather complex. So I also want to mention that because of the language in state law and statute, and therefore the language of this new law, we will be using the word victim in the slides throughout, even though we often use the word, or prefer the word, survivor. So I just wanted to mention that so you aren't wondering why that word is appearing everywhere. All right, so a quick summary of the new law. With some exceptions, victim accompaniment gives survivors of sexual assault, human trafficking, child sexual abuse the right to be accompanied, or the right to request accompaniment of a trained sexual assault victim advocate throughout the criminal justice process. And as you know, this includes the medical forensic exam, referred often as the SANE exam, various law enforcement interviews, and other subsequent proceedings. A couple of definitions. The law basically clarified an advocate to be a victim advocate. It's an individual who is an employee or a volunteer for an organization that provides counseling, assistance, support services free of charge to a victim. And again, victim refers to someone who has experienced any one of these three particular violations.
And you may recognize that definition of victim advocate seeming similar to the definition of advocate in the advocate-victim privilege statute. Well, in fact, that's where the definition for that for advocate comes from. That we decided that it would make sense to be consistent to define advocate by reference to another definition elsewhere in the statute. So you'll see that if that definition looks familiar, it certainly is. That's coming straight from the victim advocate privilege statute.
So the first part of the law entails accompaniment at hospitals. As you can see here, and many of these slides will kind of necessitate me reading or summarizing them. Basically, with some exceptions, a hospital where the individual is receiving emergency services for the assault, that hospital shall, at the request of the victim, permit an advocate to accompany them. And that's at any examination or consultation that's performed there at that specific hospital as a result of this particular crime. So one interesting point is that hospitals do not have to wait for an advocate to arrive before examining or treating the victim if the delay would endanger the health or safety of the victim or risk loss of evidence. The accompaniment in the hospitals, that right is also broken down in terms of minors, and minors who are 10 and older and minors who are younger than 10. In general, the law says that a minor who's a victim can request an advocate without consent of parent, guardian, or legal custodian. Now, for minors who are 10 years and older, the new law basically says that the parent, guardian, or legal custodian can make that request for the victim. For minors under the age of 10, a treating medical provider may make that request to have an advocate accompany the minor. Before we move on to notification, I'm just wanting to check in with folks to see if there are any questions about those particular pieces.
Is a CAC considered a hospital?
Oh, great. Someone asked, is a CAC, a Children Advocacy Center, the same as a hospital or considered a hospital? Is that... So we're actually going to discuss children advocacy centers a little bit later in the slide, because this law does actually reference them specifically. So if you can hold on to that question until we get there, that would probably be best. Okay, all right. Notification. So the hospital has to notify the victim, and if the victim is a minor who's 10 years of age or older, their parent / guardian or legal custodian. And what does the hospital have to notify the victim about? Well, two things in particular. The victim's right to be accompanied by an advocate, and that the hospital is required to permit a different or subsequent victim advocate to accompany that individual if the hospital excludes an advocate. So you may wonder, well, why number 2? Why is that there? Well, because the law includes, which we're going to touch upon, several ways or reasons in which advocates can be excluded from accompanying a victim. Part of the notification process also includes that hospitals can use a particular form that the new law says the Department of Health Services needs to create. You will see that again later in another slide. Oh, we have 2 questions.
Are the hospitals required to explain victim advocate rights right away?
So the question is, are hospitals required to explain the victim's rights right away? That's an interesting question.
Explain victim advocates right away.
I'm sorry, explain victim advocates right away. And the law doesn't really specifically address that.
When?
In terms, when they have to notify. This may be something that is addressed in implementation as we get closer to the actual nuts and bolts of how do we implement this law, what are the practices and policies moving forward.
One more question.
And one more question.
Does this apply to DV?
Does this apply to domestic violence? No. This law specifically addresses...
You want to go back to the abusive conduct slide, Dominic, just for that answer, I think, how abusive conduct is defined?
I don't think we have that as a slide.
Okay, so abusive conduct would include sexual assault of a child, or child trafficking. I thought I saw that somewhere early on, Dominic, in your presentation.
Maybe you did. One moment, please, as I look. That is part of the summary that we emailed out to folks, but I think, oh, okay, I see what you're referring to. There's actually a part of the law that mentions how they define abusive conduct and how they've expanded that a bit. Ian's pointing particularly to the definitions slide, which basically discusses victims of sexual assault, human trafficking, or child sexual abuse. So that's really those are the issues that are addressed by the law, so not domestic violence.
Unless it's a sexual assault within the context of domestic violence, right? I mean, so that would be, it would not apply to a domestic violence victim who's coming in as a result of a battery, for example. This right is really for victims of sexual assault, trafficking, or child sexual abuse. We certainly know many domestic abuse victims are also victims of sexual assault, so I think it's going to depend on how that person presents at the hospital.
Okay.
That was the slide I was referencing, Dominic.
Gotcha. All right. I used to have another slide about abusive conduct particularly, so it's gone. Okay,
So
another matter. Hold on.
Yeah, before we move on, there was a question about, when do hospitals have to provide an explanation of the advocate? The law doesn't specify a time. However, clearly the law does talk about providing victims notice of that right. For that right to be meaningful, that's going to require a prompt notification. So the law doesn't specifically say, at what time, but I think just by virtue of looking at the statute and certainly intentions behind it, given that there's a notification requirement for this right, that's going to be helpful to be done at an early stage, and certainly that is best practice. And in many cases, we know that's already happening. But I think for the right to be meaningful, and the fact that there is a notification requirement, that's going to happen early on, but the law doesn't give a specific time frame.
I see another question. The definition of victim, and I'll scroll back to that slide. Thank you for these wonderful questions and for embracing my quick movement through slides. The definition of victim advocate seems to exclude an advocate that does not work for a SASP, including campus advocates and advocates who may work for organizations whose purpose extends beyond just services for victims. Do you have any insights on this? Is there protection within this law for access to those advocates? So, go ahead.
Yeah, I mean, so the definition of the advocate, as I mentioned, comes straight from the advocate victim privilege statute. So that was certainly intentional on our parts, and I think it will not include, for example, system-based advocates. And I'm really thinking there, victim witness professionals, advocates within law enforcement agencies, because again, note the purpose of which that organization, the purpose of the organization is to provide counseling, assistance, or support service free of charge. Campus advocates, I mean, I think that's a good question. Someone who's based in a campus, I don't know if they're going to meet the definition there of from the privilege statute. And so our focus on this right and this legislation was on community-based advocacy and providing the protections that community-based advocates have with confidentiality, as well as the fact that those advocates are able to offer services beyond beyond a system responding in some way. So victim witness, they really operate within the confines of the criminal justice system. Community-based advocate is able to work with survivors prior to, during, and after that system.
We have another question here. Writing the timeline of notification of advocacy into the protocol would help. I guess that's more of a comment than a question. Thanks, Jennifer. Duly noted. Duly noted.
And the other thing, I think, depending on, before we go down too far on the campus route, some campus employees are considered responsible employees as far as Title IX and may have reporting obligations. And so, again, our focus on referencing the privilege statute is to tie it to the confidentiality protections entailed in that statute. So it was really intentional by looking at the definition of advocate from the advocate victim privilege statute.
Excellent. These are great questions. All right, I'm going to move us back to where we were, which was notification, hospitals. We've covered that. Now we're going to move to advocate exclusion. A victim advocate can request that, a victim can, hold on.
Keep going, Dominic.
A victim can request that the victim advocate be excluded from any examination or consultation, and the victim advocate must comply with the victim's request. Hearing no questions on that, moving on. Hospital can also exclude the victim advocate for any of the following reasons. The presence or continued presence of the victim advocate obstructs the provision of necessary medical care to the victim, for instance. Keep going. The victim advocate fails to comply with hospital policies governing the conduct of individuals accompanying patients in the hospital. Number 3, the hospital has knowledge that the victim advocate in his or her role as a victim advocate at any hospital has taken one of the following actions and is more likely than not to take that action again. A, failing to agree or comply with confidentiality requirements relating to another individual at a hospital. B, failing to comply with a request by a victim to exclude the advocate. Let's just hold here for a moment and see if we have any questions. I should note that these pieces of the puzzle were certainly part of our long negotiations and compromises necessary to keep the bill alive. And actually, we instituted or we added to the bill various things to try to mitigate some of these issues. For instance, and is more likely than not to take that action again. That is a pretty high bar for any hospital to basically have to substantiate, and therefore the hope is that this will all be reasonable. Any questions? All right, moving on. So the bill or the law also includes immunity from civil liability for hospitals. A hospital and its employees or agents are immune from civil liability for allowing that advocate to accompany the victim. Any failure to comply with any requirement of this law, that's any failure at the hospital, any act or omission by the victim advocate. Confidentiality of patient healthcare records. The law also allows a healthcare provider to release part of a patient's healthcare record to a victim advocate who's accompanying that victim. They're not allowed to release a copy per se, but this is certainly intended to be helpful to the care of the survivor. Now, here are some requirements on the State Department of Health Services. We mentioned this a little bit before. In the next slide, you'll see. But first, DHS has to respond to any complaint it receives concerning a hospital not complying with the new law. DHS must also, quote unquote, in cooperation with the State Department of Justice, develop guidelines for hospitals regarding the new law. They must also provide assistance to hospitals as necessary for the law. Essentially, this means that the two agencies are going to need to work together to create not regulations, but quote-unquote guidelines.
Before we move on, I think those are important provisions, given some of those, as Dominic talked about, compromises we had to make to see this move forward. That, you know, again, there is the right for complaints. So if there are issues regarding advocates being excluded, I think, you know, there is a mechanism to hopefully address those, and that, you know, again, the DOJ and DHS working on guidelines to help with the implementation of these laws, and certainly to clarify, you know, the intent behind this to allow victims to have advocates present if they so choose.
Great, thank you, Ian. And thirdly, DHS has to prescribe a form hospitals can use. Those hospitals do not have to use the form, as I mentioned, to notify victims as well as parents, guardians, or legal custodians if the victim is a minor who's at least 10 years of age, 10 or older, of the victim's right to be accompanied by a victim advocate. That's a little convoluted, and I'll give you all a second to digest it. Folks might be wondering, what does it mean to prescribe? Well, it has nothing to do with medication, as far as I'm aware. However, it is, you know, to create a form. The hospitals are going to, no, excuse me, DHS is going to need to create a specific form the hospitals can use to notify victims about their rights under this law. I hope that helps clarify the obvious gobbledygook. Further notification, the DHS notification form has to include these three things: the victim's right to request accompaniment under the law, the right to exclude a victim advocate should the victim choose to do so, and the procedure for making a complaint to DHS, which we mentioned just a moment ago. I do see a question. If an advocate reminds medical personnel that victims are allowed to refuse any part of the exam, is this considered to be obstructing the process and grounds for asking an advocate to leave? Good question.
I mean, I think it's a good question. You know, we don't, all we have right now are the words in the law, which says obstructing and delay. I would, again, where the relationships between the advocates and the hospitals are solid, we would not expect there really to be any problems with regarding to advocates explaining the rights of victims and explaining the options for survivors. So, you know, there's nothing saying that that is going to be obstructing. On the other hand, right, when we have language that sometimes can be not 100% clear, then there's room for interpretation. But remember again, the rights to complain, that, you know, we would hope that's not obstructing or delaying. We use those words to try and signify that this was, you know, had to be something significant that the advocate was doing that was interfering or in the exam. And I would think my answer to that would be no, that's not obstructing or delaying. But again, this is much is gonna happen here depending on who's doing the exam. But I think our partners at DOJ and who are sane forensic nurses understand the importance of advocates and understand the role they have to play. So I would not expect that that would be a huge problem. But again, as this law goes into effect, we need to hear what if there are problems or questions regarding how the law is being implemented.
Thank you. Now moving on to basically the other half of the new law. First half was medical, you know, hospital. Second half is law enforcement. With some exceptions, the victim has the right to be accompanied by an advocate at law enforcement interviews and at interviews and proceedings at which the survivor is requested or allowed to attend related to the crime committed against the survivor. Now, that includes the four following things, and this is strictly from the statute or the law. Prosecution interviews, Department of Corrections proceedings, court proceedings, and post-conviction proceedings. A parent, guardian, or legal custodian of the victim who's a minor may request an advocate to accompany the minor victim at law enforcement interviews and interviews and proceedings. Oh, I'm sorry, there's a question. So to back up a bit, is the healthcare provision specific to hospitals only or to all ambulatory healthcare settings? I think I can answer this actually. The specific language is a hospital in which a hospital that provides emergency services to a victim of sexual assault, human trafficking, or child sexual abuse. So it looks like it's directly about hospitals. I also see another question. Does that include child first interviews, forensic interviews? We're going to, thank you very much, Amber. We're going to discuss that in subsequent slides. So if you can just hold on to that, you'll hear more. Notification. The accompaniment law basically does not address the issue of notification of the accompaniment right when we're talking about law enforcement interviews and subsequent proceedings. I do see another question. Does this include accompaniment to revocation of probation / parole proceedings?
Hi, this is Ian. I think yes, by reference to the inclusion of not only DOC proceedings, but post-conviction proceedings. Post-conviction would include your probation, parole / extended supervision revocation hearing. And we specifically wanted to include those in this law.
Excellent. Okay, so advocate exclusion. So as in the hospital portion, the law enforcement portion also includes some ways in which, or reasons why, an advocate might be excluded from the interviews and proceedings. So advocates risk being excluded if basically they do any of the following. If victim advocates, for instance, victim advocates cannot obstruct or delay a law enforcement interview. If they do that, obviously they will risk being excluded. Advocates shall comply, so they must comply with the victim's requests or instructions. Advocates must comply with any rule, policy, or requirement established by the law enforcement agency regarding confidentiality of information relating to an investigation. And now I see some questions. Let's see. Does that mean that during a revocation hearing, an administrative judge cannot exclude an advocate anymore with this law? That's an interesting question, Ashley.
Again, the right to accompaniment includes various proceedings, one of which is post-conviction proceedings. And that is now part of Chapter 950. So that's a crime victim right under Chapter 950. It has, enforceability under that statute. So the question being, does that, again, right, I think victims have the right to accompaniment. And I would read this as, yes, that means at post-conviction proceedings that if advocates were being excluded, a victim could complain under Chapter 950.
Okay. I also see another question. By minor, do you mean under 18 or under 10 for law enforcement interviews? So for this part of the law, we're referring to folks who are under the age of 18 in general. I see another question. Can an advocate attend criminal justice proceedings if the offender is a juvenile?
The offender is a juvenile.
I mean, Ian's looking more specifically at the statute, but at first blush, the law doesn't really go into that kind of detail.
Yeah, it doesn't. However, again, I note the right to accompaniment, an individual who is a victim of a violation of crimes including 948.02, 948.025, right? Those are child sexual assault crimes. And proceedings at which they're requested or allowed to attend. Again, if they're allowed to attend, if they're requested to attend, I would be reading this as, yes, an advocate can attend those proceedings. Again, we may need to wait until we can get some guidance on that, but as I'm reading the statute, it clearly applies to child victims, and it also talks about interviews and proceedings at which they're requested or allowed to attend.
Great. Thank you. Now, part of the list of possible reasons why advocates can be excluded from law enforcement interviews and other proceedings is the following, and this is a little long. Victim advocate may not disclose information that's not previously disclosed to the general public to any person. There is one exception, but to try to put that number 4 in clearer language, basically an advocate cannot disclose and can't make public information that's not already made public. Now, the exception to that is a victim advocate may disclose information to an individual or an agency that's providing counseling, assistance, or support services to the victim, to the extent that disclosure of this information is reasonably necessary to assist in the provision of counseling, assistance, or support services. So we intended for this to be included such that folks who are at sexual assault service providing agencies and other service delivery organizations are able to do their job in terms of being able to communicate with their supervisors, be able to communicate with their colleagues and other entities as necessary to provide the services, support, and information to survivors.
Right. I think that's right, Dominic. And so on the previous slide, can you go back a slide, please? Right. There's that, we risk, or advocates risk exclusion. They don't comply with confidentiality regarding law enforcement investigation, right? You can probably see here some language where we had to compromise, but part of that compromise was this following slide, making clear that advocates could talk to their clients and could talk to their supervisors, right? We're not trying to limit their ability to do their job. It's just that law enforcement was concerned about protecting information about the investigation. That's understandable. And so, right, advocates can still do their job as it relates to talking with their clients, with their colleagues, supervisors. It's just that they're not to release information not previously disclosed to the general public. Well, again, you don't do that anyways because you don't release information without the permission of the client.
Good. And we do have a question here. Is there concern that an agency would be seen as law enforcement? The individual says, I believe that law enforcement would see this as a loophole to confidentiality as victim service agency is not identified. I'm not entirely sure what the question
I'm not
is.
entirely sure of the question, and maybe that's something we could talk about offline. Deb, if you're welcome to email myself or Dominic, and we can talk further about that, just to allow for some clarity in the question, but not to hold up the webinar.
All right, very good. Moving on. So important to note, if a victim advocate is excluded from a law enforcement interview, the victim can request a different victim advocate to accompany them. So it's not a one-and-done situation. Immunity from civil liability. A law enforcement agency and its employees or agents are immune from civil liability for allowing a victim advocate to accompany the victim, any failure to comply with any requirement of this law, and any act or omission by a victim advocate. And this parallels the hospital immunity from civil liability as well. Now we come to child forensic interviews, including child advocacy centers, harkening back to some questions on that matter. So we did a bit of outreach during negotiations, outreach to service providers, experts, etc., on best practices for community-based sexual assault victim advocates when it comes to child forensic interviews, as well as child advocacy center situations. And essentially, best practice, I understand, is for the victim advocates to remain outside of the interview room while a victim who is a minor is being interviewed, that is to say, during the forensic interview at a child advocacy center. During the interview, we hear that advocates typically provide support to a young victim's family anyway. That's usually their role. So the following comports with that. Victim advocates can be excluded from a child forensic interview and the child advocacy center. A victim advocate cannot obstruct or delay a forensic interview conducted at or on behalf of a child advocacy center. A victim advocate must comply with any instructions or requests from the lead forensic interviewer, including excluding himself or herself, that is the advocate, from the interview room. The advocate shall comply with any rule, policy, or requirement established by the Child Advocacy Center. Some of this parallels the exclusions in the law enforcement slides you saw previously. Actually, let me stay on that slide for a moment. Any questions about this? Realizing, of course, that there were some questions about child advocacy centers. Does anyone want to ask questions about this? Okay, all right. And then here is advocate-victim privilege. The law clarifies the state's existing confidentiality and privilege statutory language by replacing advocate with victim advocate in various parts of the law. That's just a tweak. So the initial applicability and effective date of this bill is as follows. We should first note that the victim accompaniment law is not retroactive. In other words, it only applies to violations committed against the survivor on or after the date that the new law takes effect. The new law takes effect on August 1st of this year, 2016. That is, in statutory language, the first day of the 4th month following publication of the law. So if you follow that equation, it eventually gets you to August 1st of 2016. So next steps. Well, getting a bill through the legislature and signed by the governor is only a part of the process of creating law and implementing law. The second part is implementing that law, which is often just as long and sometimes just as complex. Essentially, based on the slides you've seen, there are a few things that we expect that are going to be key to work on and watch. For instance, together, the Department of Health Services and the Department of Justice in the state have to develop guidelines for hospitals to follow. Both those agencies also need to provide some sort of additional assistance to hospitals in dealing with this new law. DHS must also design that optional notification form for hospitals. And of course, developing and implementing outreach and trainings for all key actors is going to be key, shall we say, very important. Those main actors involve community corrections, prosecutors, assistant district attorneys as well as prosecutors, law enforcement officers, sexual assault nurse examiners, other hospital staff that are involved in these processes, and of course sexual assault victim advocates. So, I mean, that basically takes care of the webinar. And if you do, but the slides, we are here for addressing questions for quite a while more. But I wanted to include these links so that, you know, you can go and explore the new law. There will be what we call a Legislative Council Act memo at some point, hopefully soon. That is a couple-page summary and explanation of the new law. That link will be accessible via the first link you see. Then, of course, there's information about the bill that became law. And why that's important is that you can go and see who are the folks who testified at a hearing for the bill, who are the folks who registered in favor of the bill on the Government Accountability website. You can see amendments and other aspects, you know, who voted for the law, who authored the law, et cetera. And then, of course, there's the link to our state public policy page that includes a wealth of other information, and then the legislature's homepage, and then, perhaps most importantly, to find out who represents you in the legislature, use the following last link. And for questions, concerns, and considerations, please feel free to reach out to us, Ian and myself. There's our information. This is a lot of information that we put out there, so please feel free to ask us questions. Even if the question may seem obvious, or you may feel, oh, this is really a silly question, I shouldn't ask. Nah, you know, as you always heard in school, a lot of other people have the same question, I'm sure, and we'll do our best, of course, to answer it or follow up. We've got one. Can you summarize how this law changes from existing policy or law in regard to victim accompaniment? Great question, Diana.
Sure. I think what it does is it changes. It's a change from existing law in that there was not similar law regarding advocacy presence at hospital, forensic exams, or law enforcement interviews. You may be aware of the service representative statute, which has a more narrow application, and this does not impact that right as it exists already. In terms of policy, I think my response to that would be this is a codification of best practice policy that is happening already in many parts of the state. We understand that in many parts of the state, this was a process that is already happening, and I think this law is just codifying that best practice or that best policy. But it is new. These are new provisions, and they are new rights under Chapter 950, and they are new rights under the hospital, Chapter 50 regarding hospitals. So I hope that answers your question.
And yes, these slides will be available for you to share with folks. I also have a summary of the law, which essentially is the same thing, but it's not in slide form, so it's a little more accessible. That I will, in fact, it's often the same exact language, but I will share that with you all also here, hopefully this week. Other questions or thoughts? Well, let's see. It's been about an hour. We still have time. Oh, and again,
there's a question. If an advocate explains what a sane exam is to the victim, and the victim changes her mind to the exam, is that impeding the law enforcement investigation? Well, I think the choice to have a sane exam belongs solely to the survivor. There's no requirement that the sane exam is a part. I get that it can be part of a law enforcement investigation, but there's not a requirement that it be so. So I think that would be a stretch in terms of interpreting this law. Certainly not the intention behind it. That would be my answer to that.
Great. All right. Well, thank you, everyone. And again, I'm sure folks will have questions in the next hour. For instance, as things begin to really, oh, here's a question. We're experiencing, a couple questions. Hold on.
Okay.
We're experiencing a shift in our SANE provision.
Yeah, I'm aware of that. Hi, this is Ian. Certainly aware of the issue. Jennifer, the question, does this law affect advocacy crossing county lines? The law is in effect statewide. The rights apply to a victim anywhere in the state. So yeah, I don't see it being limited by county or geographic lines other than perhaps state borders. But I'm aware of the issue you're referencing. I think that's a separate issue regarding availability of SANE exams, but the law applies in every county in the state.
Thank you. And then we have a couple more questions. If we remind them that the survivor, I think, that they do not have to sign the medical release forms as their right, or do not have to consent to photographs, etc., how can we remind law enforcement that this is their right and not advocacy imposing on investigation? Well, I think that kind of goes back to what you were saying, Ian, earlier. This is going to be part of that natural push and pull of implementing the law.
Right. Yeah, I think, Amber, advocates have been explaining victim rights from day one and will continue to do so. And where we have well-functioning multidisciplinary responses, this is not an issue, right? Because everyone understands the role each of us has to play. Law enforcement understands advocacy, advocacy understands law enforcement, and this is not an issue. Where sometimes those issues, maybe it's not as well functioning or there's not as great of an understanding of roles, we also recognize that this law is not going to solve every problem as far as responses. So again, right? If the victims have those rights, I don't see how that's impeding an investigation. But again, that's why we have CCRs, that's why we have SARTs. Remember, these rights are codified in Chapter 950 with respect to law enforcement, and so there are mechanisms to address violations. I don't think I see this being a widespread problem, but again, if this is happening, we certainly need to hear about it. So we want to hear about challenges in the implementation. We want to hear about successes too. I think I am optimistic there are going to be far more successes than challenges. So appreciate the question. Could you please clarify again the rights of a victim under 10 versus a victim over 10? Dominic, do you want to?
Yeah, I can do that.
Go back to that in the medical.
Yeah. So it starts off. So there are 3 slides on this. First, broadly, a minor may request a victim advocate.
Keep going, Dominic.
Victim advocate to accompany him or her without the consent. So minors have the right to request accompaniment at hospitals. Minors of any, well, minors, so it looks like minors of any age. Then minors who are 10 years of age and older, a parent, guardian, or legal custodian of a minor who's 10 or older can make a request for accompaniment as well. Then, minors who are under the age of 10, for them, a treating medical provider may make the request for accompaniment. Those are the 3 key parts for minors with regard to accompaniment at hospitals. And then in law enforcement, this kind of age bracket doesn't really exist under the law. Does that answer your questions? I think a lot is going to, I think there's going to be some interpretation, some working out of, okay, with these 3 slides, these 3 pieces of minors of any age, minors who are 10 and above, minors who are under 10, how do those pieces of the law work together? What do they mean in terms of the overall intent of the law? So I think that there is still going to be some interpretation that's going to go along in terms of understanding, obviously, all parts of the law, but also these 3 pieces under accompaniment for minors.
There's another question. Will there be a standard expectation for basic education advocate training, core competencies? Certainly that's not part of this law per se, right? There's nothing in here about in the statute about education. However, WCASA does have a basic sexual assault victim advocacy school. We have one coming up next May, and that core advocacy training is a hallmark of SAVIS. That's what we call it, Sexual Assault Victim Advocacy School, where we're talking about responding to the hospital, responding to law enforcement interviews, educating advocates about the law. So that's part and parcel of what we do here at WCASA, and we are going to continue doing that. But I mean, it's not specific to the legislation. We kind of view that as part of our mission to make sure that advocates are trained and that new advocates understand what the role of the advocate is in not just systems, but with respect to survivors as well.
Thank you, Ian.
Yep. Yeah, and that's just SAVIS. We have our training institute. We do ongoing trainings like this one. We hold webinar. We have a webinar series that we do 6 times a year, and then we schedule ones kind of on an impromptu basis like this one. So the training of advocates is something central to the mission of WCASA, and absolutely we will continue to do that.
Well, thank you, everyone, for your participation in this. We look forward to working with you all in implementation of this law. Again, as Ian said, please reach out to us. I'll get you to that slide.
It's a question about does the victim rights law have a remedy? Yes, under Chapter 950 and Chapter 50. the immunity is about civil liability. Victims would have the same right, the same remedies under Chapter 950 as they would have to any other 950 violation. But you're correct that there is an immunity from civil liability. However, the enforcement mechanisms under Chapter 950 would still be applicable.
Great. Thank you, everyone. Again, please reach out to us with questions and letting us know how things are going as we move forward in the next months and years with this work. Have a lovely day.
Thanks everyone.
Again.